Donald Trump just threatened legal action against Trevor Noah, not over journalism, not over allegations, but over a joke made on live television. And that detail matters, because it immediately tells you this is not about facts or accuracy. It is about power, intimidation, and the use of the legal system as a weapon. The joke itself lasted less than 30 seconds. It was delivered on a Grammy stage by a comedian in front of a live audience that laughed because everyone understood what it was: satire, not reporting, not an accusation, just a joke. But by the next morning, the response was not dismissal or indifference. It was a public threat, a long post promising lawyers, lawsuits, and consequences. That reaction should stop you, not because the joke was especially clever or especially offensive, but because of who reacted and how. When a powerful political figure responds to comedy with litigation threats, that is not normal behavior. It is a signal, a warning to anyone else watching closely. From a legal perspective, this threat makes very little sense. Defamation law does not work the way it is being suggested here. Satire is not treated as fact. A joke is not a factual assertion. And public officials face the highest possible legal burden when they attempt to silence speech. Which raises the obvious question. If this case is so weak legally, why make the threat at all? The answer is not found in courtrooms. It is found in strategy. Threatening lawsuits creates fear. Fear changes incentives. Fear causes journalists, entertainers, and commentators to pause, soften their language, or avoid certain subjects altogether. That is the chilling effect, and it works even when a lawsuit is never filed. This is not about winning a case. It is about sending a message. About reminding critics that speaking freely can come at a cost. From an investigative standpoint, this moment is revealing because threatening litigation does not close doors. It opens them. It invites scrutiny. It invites questions. And it risks turning a joke into a legal minefield for the person who issued the threat. So before asking whether this lawsuit would succeed, there is a more important question to answer. What happens when defamation law is weaponized? What happens when power attempts to dictate what is allowed to be said, even in comedy? This is not just about Trevor Noah, and it is not just about one joke. It is about how far intimidation is allowed to go, and what happens when no one pushes back. Donald Trump's response did not come quietly. It came publicly, forcefully, and with intent. Within hours of the joke airing, he posted a lengthy statement laying out his version of events and, more importantly, his threat. This was not a casual dismissal. It was a calculated message. In that post, Trump claimed the joke was false and defamatory. He stated that he had never been to Jeffrey Epstein's island and suggested that the comment crossed a legal line. He framed himself as the target of a baseless accusation, one that demanded a response not through rebuttal, but through lawyers. The language was aggressive. The tone was unmistakable. Lawsuits were promised. Consequences were implied. He also pointed to recent legal settlements involving major media organizations: ABC, CBS, large payouts. Those references were not incidental. They were included to establish leverage, to signal strength, to remind anyone watching that litigation, even when it does not go to trial, can be costly. This was not just a defense. It was a warning. What matters here is not only what Trump said, but how he said it. He did not engage with the substance of the joke. He did not explain context. He did not acknowledge satire. Instead, he recast a comedic remark as a factual allegation and treated it as though it were investigative journalism. That framing is essential to his claim, because without it, the legal argument collapses. There is also an important omission. Trump's statement focused narrowly on one point: the island. He denied ever being there, but the joke itself did not assert that he was. It relied on implication, exaggeration, and cultural reference. Comedy. By reducing the joke to a literal accusation, the response stripped it of context and replaced it with a version that could be attacked. This is a familiar pattern. Take an ambiguous or satirical statement, flatten it, treat it as a false factual claim, then threaten litigation. The goal is not clarity. The goal is control of the narrative. From a legal standpoint, this approach is fragile. Courts do not evaluate speech the way social media posts do. They examine context, intent, and how a reasonable audience would understand the statement. But from a political standpoint, the move is effective. It shifts attention. It creates a spectacle. It forces the conversation onto Trump's chosen terrain. At this stage, no lawsuit has been filed, only a threat. And that distinction matters, because threats are cheaper, faster, and often just as effective. They dominate headlines without triggering the risks of discovery or sworn testimony. This is the public claim. This is the posture. And this is the version Trump wants people to accept. The question now is whether the law supports it, and whether the strategy holds once legal standards are applied. To understand why this lawsuit threat is so weak, you have to start with a basic principle of defamation law. Courts do not read words in isolation. They read context. Always. Who is speaking matters, where they are speaking matters, and how a reasonable audience would understand the statement matters most of all. Strip away any one of those elements, and the analysis collapses. Trevor Noah was not acting as a journalist. He was not presenting a report. He was not making a factual claim for verification. He was hosting an awards show, a comedian, on a stage built for entertainment, in front of a live audience that laughed, immediately, because the point was understood as humour. That laughter is not incidental. In legal terms, it is evidence of context. It shows how the statement was received. It demonstrates that a reasonable viewer understood the remark as satire, not as an assertion of fact. Defamation law hinges on whether a statement can reasonably be interpreted as making a concrete factual claim. A joke that lands as a joke does not meet that standard. This distinction matters because defamation requires more than offence. It requires a false statement of fact, something specific, something verifiable, something that can be proven true or false. Satire does not operate that way. It relies on exaggeration, implication, and cultural reference. Its purpose is commentary, not reporting. Courts have repeatedly recognised this difference. They look at tone, they look at setting, they look at whether the statement uses the language of fact or the language of humour. And when speech clearly signals parody or satire, judges do not treat it as literal truth. They treat it as protected expression. That is where this threat runs into immediate trouble. The joke in question did not say Trump committed a crime. It did not claim he visited a specific place at a specific time. It did not assert a provable event. It made a comparison, a satirical one. The kind that only works if the audience understands it is not meant to be taken literally. By reframing that joke as a factual allegation, Trump's response ignores how speech is actually evaluated under the law. You cannot remove a line from its setting, strip it of tone, and then pretend it was delivered as sworn testimony. Courts do not allow that kind of rewriting. If jokes are treated as facts, then context no longer protects speech. Comedy becomes liability, and satire becomes impossible. That is why this line matters, not just for this case, but for every public figure who might prefer silence over criticism. Because once jokes are reclassified as defamatory statements, free speech stops being a right. It becomes permission-based. And that is exactly the danger here. Even if the joke were treated as a statement of fact, which it is not, Trump would still face a nearly insurmountable legal barrier. It is called actual malice, and it exists for a reason. Donald Trump is not a private citizen. He is a public official. That status fundamentally changes the rules of defamation law. Under long-standing Supreme Court precedent, public officials must meet the highest possible standard to succeed in a defamation claim. They must prove that the speaker knowingly made a false statement or acted with reckless disregard for whether the statement was true or false. This is not about tone. It is not about offence. It is not even about accuracy in the ordinary sense. Actual malice is a specific legal threshold, deliberately set high to protect speech that criticises those in power. The law assumes that open debate about public officials will be messy, uncomfortable, and sometimes unfair. That is not a flaw. It is the point. Here is the problem for Trump. You cannot prove actual malice when the speech at issue is clearly satire. A joke does not assert truth. It does not present evidence. It does not claim certainty. It signals the opposite. Humour relies on exaggeration and implication, not on factual precision. That alone makes the actual malice standard almost impossible to satisfy. To establish actual malice, Trump would need to show intent. He would need to demonstrate that Trevor Noah either believed the joke was false while presenting it as fact, or consciously ignored serious doubts about its truth. That argument collapses on contact with reality. There was no attempt to present facts. There was no pretense of reporting. There was a punchline. Courts have been clear on this point. The First Amendment requires what judges often call constitutional breathing space. Public debate must be given room to operate without fear of punishment. That includes speech that is sharp, caustic, and deeply critical, especially when it targets those who hold power. This standard exists because the alternative is worse. If public officials could sue over satire by claiming emotional harm or reputational offence, criticism would dry up overnight. Political commentary would become timid. Comedy would become dangerous. And accountability would become optional. That is why actual malice functions as a wall, not a guideline. It is meant to stop cases like this before they ever reach a jury, not because the speech is polite or fair, but because democracy depends on protecting it. From a legal standpoint, this case does not struggle. It does not wobble. It fails outright. The standard is too high, the context too clear, the intent too obviously comedic. And that is precisely why the threat itself deserves scrutiny. Satire is not a loophole in the legal system. It is a cornerstone of it. And the reason it receives such strong protection under the First Amendment is simple. Without satire, democratic accountability collapses. American courts have understood this for decades. Satire exists to challenge power, to exaggerate its flaws, and to say out loud what polite discourse often avoids. It is not meant to be fair. It is not meant to be balanced. It is meant to provoke, to unsettle, and to force reflection. That is precisely why those in power so often resent it. The Supreme Court confronted this issue directly in a landmark case involving a public figure who claimed he had been deeply harmed by a parody. The court did not ask whether the satire was offensive. It did not ask whether it was cruel. It asked one question only. Would a reasonable person believe the parody was stating actual facts? When the answer was no, the case ended there. That reasoning matters here. Satire signals itself, through tone, through exaggeration, through context. It tells the audience, implicitly, do not take this literally. That signal is what separates protected speech from defamation. And in this case, the signal could not be clearer. A comedian, an awards show, a punchline, laughter. If that kind of speech loses protection, the consequences are immediate. Political cartoons become legal risks. Late-night monologues become liabilities. Humour aimed at presidents, governors, and lawmakers becomes grounds for lawsuits. The law would no longer shield criticism. It would punish it. Courts have rejected that outcome repeatedly. They have done so because satire plays a unique role in public life. It reaches audiences that legal briefs and policy debates never will. It simplifies complex power dynamics. It exposes hypocrisy. And it does so in a way that is accessible, memorable, and often uncomfortable. This is why satire is treated differently from reporting. Journalists are expected to verify facts. Satirists are expected to challenge assumptions. Confusing the two is not a mistake. It is a tactic. One that allows powerful figures to claim injury where none exists and to frame criticism as defamation. But the Constitution does not bend to discomfort. It protects speech precisely when it is inconvenient to those in authority. Especially then, when a public official threatens legal action over satire, the issue is not hurt feelings. It is whether the legal system will hold the line. Whether courts will continue to recognise that free expression includes humour, mockery, and exaggeration, or whether intimidation will be allowed to redefine the boundaries of speech. That is why this moment matters, not because of one joke, but because of what happens if satire stops being protected. Threatening a lawsuit is easy, filing one is not, and that difference matters, because once a case is filed, control shifts, not to the plaintiff, to the process. That process is called discovery, and it is where legal threats often turn into legal minefields. Discovery is the phase of litigation where both sides gain the power to demand evidence, documents, emails, text messages, phone records, testimony under oath. It is not optional. Once a lawsuit begins, discovery follows, and it cuts both ways. This is why experienced litigators are cautious about defamation claims, especially when the plaintiff is a public figure. Discovery does not stay neatly confined to the narrow claim asserted in a complaint. It expands, it asks questions, it pulls threads, and once those threads are pulled, they cannot be easily put back. If a public official sues over a joke that references a sensitive topic, the defense gains leverage. They can argue that context matters, that truth matters, that background matters, and to make that case, they are entitled to probe the underlying facts. That means subpoenas, depositions, sworn answers to uncomfortable questions. This is not speculation, it is routine. Defamation cases regularly collapse at this stage, not because the law favours defendants, but because plaintiffs decide the risk is not worth it. Discovery exposes far more than the original statement ever did. That is what makes this threat so revealing. A lawsuit here would not silence discussion, it would intensify it. It would turn a fleeting joke into months or years of legal examination. Every attempt to claim harm would invite scrutiny into the very subject the plaintiff claims to want to avoid. From a prosecutor's perspective, this is a red flag. You do not walk voluntarily into a process that forces disclosure unless you are prepared for what comes next. You do not invite sworn testimony unless you are confident it will help you. And you do not gamble on discovery unless your goal is something other than winning cleanly in court. That is why legal threats are often more useful than legal action. They create headlines without consequences. They intimidate without disclosure. They project strength without triggering the machinery that could undermine that image. But if the threat becomes a filing, the calculus changes instantly. The spotlight widens, the questions multiply, and the plaintiff loses the ability to control the narrative. This is the legal minefield hidden behind the bravado. And it is the reason so many defamation threats never become cases. Because once the door to discovery is opened, it does not close quietly. At this point, the pattern should be clear. This is not about winning a defamation case. It is about something far more effective: silence. In legal terms, this tactic has a name: the chilling effect. It describes what happens when the threat of punishment, rather than punishment itself, changes behaviour. People hesitate, they self-censor, they avoid topics that might attract attention from those with power. Litigation is uniquely effective at producing this effect. Lawsuits are expensive, time-consuming, stressful. Even when a defendant is confident they would win, the process itself can be punishing. Years of legal fees, endless filings, public scrutiny. That cost alone is often enough to discourage speech. This is why legal threats are so often aimed not at the weakest targets, but at the most visible ones. Journalists, broadcasters, comedians with large platforms. The message is not meant for the defendant alone. It is meant for everyone watching. When a public figure threatens to sue over satire, the signal is unmistakable. Criticism will be met with force. Humour will be treated as hostility. And anyone who crosses the line, however vaguely defined, should expect consequences. The effectiveness of this strategy does not depend on legal merit. In fact, weak cases can be ideal. They allow the plaintiff to posture publicly without risking a courtroom loss. They dominate headlines, they shift narratives, and if the case never gets filed, the chilling effect still lingers. This is how speech is narrowed without laws being passed. No censorship statutes, no formal bans, just pressure, just fear, just the quiet understanding that certain jokes, certain questions, certain topics are no longer worth the trouble. The danger of this approach is cumulative. One threat might seem trivial, two can be dismissed as bluster, but over time, the boundaries of acceptable speech begin to shrink. The loudest voices become quieter, the sharpest criticism dulls, and what remains is a safer, more cautious public discourse that serves those already in power. That is why courts have historically taken the chilling effect seriously. It is not hypothetical, it is measurable. It alters behaviour, and once it takes hold, it is difficult to reverse. This moment fits that pattern, not because of what was said on stage, but because of how it was answered. The threat itself is the point. The lawsuit is optional. And that is why this deserves attention, because when intimidation becomes routine, free expression does not disappear all at once. It disappears one threat at a time. Before closing, one point needs to be made clearly. This analysis is not about personal allegiance or political preference. It is about how power responds to criticism and what happens when the legal system is used as a deterrent rather than a remedy. From that perspective, the most concerning aspect of this episode is not the joke itself, but the instinct to answer satire with intimidation. When comedy, journalism, or sharp commentary is met with legal threats instead of argument, the message is simple: speak carefully, or do not speak at all. That dynamic has consequences far beyond any single dispute. This content is presented for commentary and analysis purposes only. It discusses publicly reported events and general legal principles related to free speech and defamation law. Nothing here should be interpreted as a factual allegation of criminal conduct against any individual, nor as legal advice. All individuals mentioned are presumed innocent unless proven otherwise through due legal process. With that context established, the broader issue comes into focus. Legally, this threat is weak. The standards are high. The context is unmistakable. Satire is protected speech, and public officials face an extraordinary burden when they attempt to claim defamation. On the merits alone, this case would struggle to survive. But the real impact of this moment has little to do with whether a lawsuit is ever filed. It has to do with normalization. Free speech does not disappear overnight. It erodes gradually. One threat discourages one joke. Another softens a headline. Another convinces someone that speaking openly is not worth the cost. Over time, the boundaries of acceptable discourse shrink, not because the law requires it, but because fear enforces it. This is why defamation law was designed the way it was. Public officials are given less protection, not more, precisely because they hold power. Criticism is not a defect of democracy. It is a requirement. When that balance is challenged, attention matters. Legal intimidation thrives in silence. It weakens when it is examined, understood, and questioned. This is not about one comedian. And it is not about one joke. It is about whether speech remains something that can be answered with words, or whether it must be defended against threats. That distinction is where democratic accountability either survives or begins to fail.